Hi, hello. Hi, everyone. Thank you for coming. In a way, Felix needs no introduction. He has been visiting the faculty from time to time, but I will still introduce him. And I always introduce him this way, and that is he's the only person, the only scholar I know who researches and teaches in both antitrust and trust. And that's a rare combination. But Felix's scholarship spans much further than just antitrust and trust. He works in a large range of fields in financial regulations, law and economics, business association, corporate law, trust and estates, succession law, a really wide range of interest indeed. And Felix always lends a very deep and broad view about these subjects. And I think the law and economics perspectives that he often brings upon them really sheds light on a lot of these subjects. So without further ado, can I pass the time to Felix, and shall we join hands to welcome him?
Hi, everyone. Lucina, thank you so much for that general introduction. Thanks for the Center on Private Law for sponsoring this. It's a real privilege to be back at HKU. So this is kind of an overview about economic analysis of trust law. And economic analysis came pretty late to trust law. In the 1960s and 1970s in the US, as the law and economics movement was sweeping from antitrust and regulation into non-economic areas of the law, the doctrinal and theoretical work in trust and estates still revolved around these really old concepts, in particular testamentary freedom, which is the animating principle for succession law. So this is really despite, I think, similarities between trust law and other fields of law where economics had already penetrated really deeply, like you have economics penetrating agency law, contract law, property, and enterprise organizations. There seems to be this natural fit, but notwithstanding the natural fit, trust law came really late to economic analysis. But like agency and contracts, trust law allocates powers and responsibilities through default rules that are going to be susceptible to efficiency analysis. And like the corporate form, trust law segregates assets into different tranches and each entailing different relationships with creditors, and therefore you got different sets of transaction cost and pricing effects. Over time, the economic analysis of trust law moved from microeconomic analysis of trust law that's focused on discrete and narrow sets of relationships to more macroeconomic focus, which envisions trust as an input into the broader economy. So in this survey today, I'll talk about kind of the roots of the first forays of trust law into microeconomic analysis. And I'll end with where I think is the most really exciting development, which is where trust law, I think, is heading into more macroeconomic analysis. All right, so for the precursors in microeconomics, a lot of law and economics, it's generally, and in trust law in particular, it traces its lineage back to this really well-known paper by Ronald Coase. He has this really influential article, The Problem of Social Costs. It's in volume 3 of the Journal of Law and Economics. So this is a really seminal text from Coase. And there Coase shows that however you initially fashion liability rules, the parties are going to contract around them to arrive at the optimal, most efficient result. There's a really big caveat because it assumes the absence of transaction costs. And a lot of the work since Coase has really worked on what exactly transaction costs means. So Coase had come about in the 1960s and he had pushed back against Arthur Pigou. So Arthur Pigou had really had this kind of faith in the availability of, or the ability of government intervention to correct for what's called negative externalities in relationships. That is, when two parties are bargaining bilaterally, they might have some sort of negative externalities that other parties are bearing. And a lot of times this was thought to be a market failure that justified government intervention. Coase comes along and says, no, however you might fashion liability rules, people in a world perfectly devoid of transaction costs are going to bargain to the most optimal result. So this is the precursor. And I think from here, the early tinkering in law and economics and trust law, I categorize them into three kind of branches. and these are the three branches I'll talk about. So you've got a sort of conception of the relational nature of trusts, and the relational nature of trust spurs two of these branches. You've got the contractarian turn and the agency costs theory. So in the contractarian turn, this is really identified very closely with John Langbein, who I think in trust circles, we know him as a trust law scholar, but really John Langbein is a legal historian. So John Langbein had said that you got these ex ante bargains, and if the parties can bargain amongst themselves ex ante, that should spur broad exculpations to standard fiduciary duties. Another kind of subset of this relational nature of trust is associated with Robert Sitkoff, and this is the agency cost theory. So as I'll talk about shortly, in a nutshell, the agency cost theory of trust law says that if you're looking at welfare calculus of the parties, that might justify a degree of dead hand control or modifications of dead hand control. And then there's this other branch, which is the asset partitioning branch. And it's interesting because there's this longstanding question of what exactly is trust and what exactly is trust law. Is it more contracts or is it more property? Well, I think it's kind of an odd fit, but people who said that you should stay true to the property roots of trust, really early on the law and economics analysis was to say that trusts are all about asset partitioning. And they think that that's really rooted in trust property features. I think I'll talk about shortly. I'm not sure because I think that that might be more of an enterprise or an entity view of trust that's not necessarily rooted in property law. But nonetheless, these are the three branches that I think of the really, really early experimentations of law and economic analysis of trust law. All right, so let's begin. Let's begin with the contractarian turn. So the contractarian turn derives really from corporate law and from trust law. So in short, this view holds that although trust law supplies default rules, the parties can contract around those default rules. So this is a contractarian view of trust. It's heavily influenced by Frank Easterbrook and Daniel Fischel. The really corporate law scholars would have extended Coase's work and argue that default rules merely approximate what the parties to contract might have bargained to ex ante as a general matter, but this is, again, absent transaction costs and enforcement problems. And fiduciary duties as a general matter do represent kind of a compromise, but if you've got parties that agree to more specific terms, the blanket duties have to yield. So this is well known in corporate circles, and in corporate law circles, this is really, you see this most clearly in business law. So here are a couple of examples. So to take exculpation as the primary example of this contractarian turn, looking at the relational nature of trust to say that you can contract around default rules. So Langbein says that you've got this consensual relationship between the settlor and the trustee, and that's in essence that trust deal. So that, because it's a consensual relationship, it's a contractual relationship, that means that if the parties so agree, they can modify any of the terms. And that includes fiduciary duties, which are really the long-standing duties that have been associated with trust law. If you look at some analogs, so Langbein was really, really influential, in a lot of his pronouncements made their way both into the Uniform Probate Code and the Uniform Trust Code. So in the UTC, here's a general comment to Section 1. It says that the Uniform Trust Code is primarily a default statute, and a lot of the code's provisions can be overridden in terms of trust. So that's taken directly from Langbein. And then you have later, as the UTC began to be promulgated with more and more specific sections, Section 1008 of the UTC, it's a little bit hard to parse, so I've summarized it rather than framing it in double negatives, which is the original language. In short, Section 1007 says you've got this exculpation of a trustee. It's not enforceable if it relieves the trust of liability for a breach of trust committed in bad faith or with reckless indifference, or if it is inserted as a result of the abuse by the trustee. That means if you don't fall within these two exceptions, exculpations of trustees are going to be freely available. Now, the way you see it in business law, and because I teach business law quite regularly, I think it's really helpful to draw a chart and to think of what kind of the duties look like and what the exculpations look like. So if you don't mind, if you would indulge me, I'm going to come here and fight for it. So in business law, in particular, if you think of this range of behavior going from bad to worse, We begin with negligence. What's worse than negligence is gross negligence or recklessness. What's worse than that? Well, you have actions that are not in good faith or actions in bad. What's worse than that? If you have some sort of an intentional conduct or a willful misconduct. So these are the different types of behavior. And on this, if we think of the types of exculpations that you get in corporate law. Well, thinking about fiduciary duty in corporate law, you've got, of course, duty of care, you've got loyalty. But fiduciary law is going to be state law. And in the US, the premier sinus incorporation is going to be Delaware corporate law. And in the Delaware general corporation law, it doesn't say exactly what the fiduciary, or what the overlay of protection are for the fiduciary duty of care. But it's well known as a matter of common law that you have a business judgment rule. So in many jurisdictions, the business judgment rule is the view of liability to breach the duty of care for a variety of conduct. Now, the business judgment rule in Delaware is not codified like a lot of states. And decisions, you've got a range of decisions that say that if you behave with negligence, you will overcome the BJR, or it really takes up the behaviors in bad faith. But the midpoint in Delaware is that if you behave with supposed gross negligence, if you can, as a plaintiff, allege gross negligence or reckless behavior, then you overcome the business judgment. But for a long time in Delaware corporate law, the business judgment rule stood in almost an airtight way of exculpating like errant fiduciary behavior. They really had to act really bad. But in the 1960s, there was a pretty well-known decision called Smith versus Van Borkum. It was the court found that the business judgment was overcome for behavior that looked ostensibly like the violation of fiduciary care. So the legislature freaked out, and then they came up with a 102B7. So 102B7 is this exculpation that you're permitted under Delaware general corporation law, where it says that you have to act in bad faith. So that means that everything south of bad faith, you're exculpated. And the ability to do all of this, in part, it's really heavily informed. It's heavily informed by this Easterbrook shell notion that if the parties agree with this charter, then that's fine. We can completely waive even the fiduciary care. So that means that with the 102B7, you started everything from here, and you really require some sort of bad faith or a breach that was into the fiduciary royalty to successfully raise the fiduciary challenge of the corporate law. And all of that is okay under Delaware because you had this libertarian revolution that has swept through corporation law in Delaware that was premised upon a lot of the research and writings of this really influential bunch of coming from law and econ. So then it's made its way into other rules as well. So around this time, you have these standard rules for other forms of enterprise organization. What's really important is partnership law. So there in the US, two forms of model acts for partnership law. One is the Uniform Partnership Act, which dates to 1914. And that took a very traditional view of fiduciary duty as something that you could not contract around. But then you have the revised Uniform Partnership Law, or the Uniform Partnership Act of 1997, that took a much more libertarian approach that had incorporated this libertarian revolution from law and economics. And what you see is a statutory matter in Delaware that allows for free exculpations of fiduciary duties. So in section 404, it basically says that fiduciary duties are going to be freely waivable. What you can't waive, though, is the fiduciary duty of good faith and fair dealing. But that's really never made that much sense to me, because what is the duty of good faith and fair dealing? It seems to come from contracts. And that is a little bit circular, a way of saying basically if you arrive at a contractual agreement, you have to abide by the good rule of good faith and fair dealing. Doesn't seem like it's very much a fiduciary duty. And RUPA section 404 provides for broad exculpations. So you had, as the Uniform Trust Code was developing at this time, as the Libertarian Revolution was percolating through corporate law and also agency and partnership law, you began to see codification. So therefore, some of the really long-standing default rules that you would get in trust world, or things that were kind of close to the trust world, like you have this blanket no further inquiry rule, which it will void conflicted transactions that are entered into by the trustee. Over time, it becomes riddled with exceptions so that you've got more holes in the proverbial cheese. It's riddled with exceptions like fairness to beneficiaries. And in a way, a lot of the libertarian revolution seems premised upon a really old understanding from agency law, which says that if you're embroiled in a fiduciary conflict, especially like if you got a violation of a really classic and inviolable duty, like the fiduciary duty of loyalty, that's okay if three things happen: if you disclose all material facts, if you get informed consent, and if it is fair. So over time, a lot of these exculpations seem to incorporate all these three elements: disclosure, consent, and fairness. So what remains then from the libertarian revolution seems to be the only thing that's left intact is really the duty of good faith and fair dealing. So you've got a real central problem here, and it's that portions of the trustee's fiduciary duties constitute this mandatory core. And it's been long thought that this mandatory core, the fiduciary duties for trust law, cannot be eviscerated by contract. The challenge is that in some of his earlier writings, as Langbein was really championing the contractarian turn, so he himself, when he assesses Easterbrook and Fischel, he does recognize that these duties embody, quote, these deep moral precepts about behavior that's appropriate for a trustee or other fiduciary. So the pushback then against this first generation is that there's some squeamishness because it seems that if you can freely waive everything, fiduciary duties seem like they should be not touchable because they embody these moral precepts. Okay. So now let's move on to the next subset of this relational turn, of this, like the relational nature of trust and the kind of the law and economics turn. That's agency, cost, and dead hand control. So natural question that follows from the contractarian approach to trust is, well, where does the trust deal leave beneficiaries? Because if the trust deal is this deal that's struck between the settlor and the trustees, and a lot of the first generation of law and economics analysis was talking about broad exculpations that were requested by the trustee, where does that leave beneficiaries? So along comes Rob Sitkoff, and he formulates this agency theory of trust law. And then he tackles this potential misalignment of incentives between the trustee and the beneficiaries. So Sitkoff builds his argument on two pillars. The first is Berlin means, so their analysis of corporation separation of entity from control. It's really well known in corporate circles. And then he also builds his analysis on Jensen and Meckling. So the notion of the firm as a nexus of contracts, and these contracts often oversee principal agent conflicts. And I think if there's the strongest criticism perhaps of Sitkoff is that he thinks that he couches this like an agency cost, but a lot of what he says is really these agency problems, conflicts between like principal agent relationships. So here's what Sitkoff says. So the way he borrows on these two pillars, he says that, like, look, since all parties are rationally trying to maximize their welfare, trust law is going to constrain the errant agent behavior by creating this governance regime that protects the interests of the beneficiaries. And they can be conceptualized as these residual claimants. The caveat, though, is that these constraints have to be consistent with the settlor's ex ante instructions. And this is a strain of testamentary freedom that I think is quite distinctly American. It's very extreme notions of testamentary freedom. What's often lost in some of Sitkoff's earlier writings, so this is a really influential Cornell Law Review piece, what's lost is that the Sitkoff is really quite pro-settler and very pro-testamentary and settler freedom. It's just that a lot of the analysis gets really wonky. So I'll try to unpack it a little bit by beginning with the criticisms. So some of the criticisms, well, again, Sitkoff's argument is, look, you want to try to defer to testamentary freedom and therefore the settler intent, unless doing so somehow eclipses overall welfare. And he's thinking in particular of the welfare of the beneficiaries. So there's some criticisms to that. One is that if you're talking about individual preferences, especially the preferences of the settlors, preferences are pretty idiosyncratic, especially in succession. So it really renders the welfare calculus nearly impossible. Welfare calculus, it's hard to say, well, what's the objective? Like, how objectively can we value how much this means to the settler when the settler has all sorts of really bizarre wishes? So anybody who studies or teaches like succession law knows that settlors are just the bizarrest things that make their way into cases and make their way into wills and trust instruments. So one is that it's really difficult to calculate what welfare is. The other thing is that the agency framework, it maps really incongruently onto these sets of relationships, like between the settler and the trustee on one hand, and the beneficiary and the trustee on the other hand. So not all of these costs are going to be agency costs. So a lot of the tensions that Sitkoff outlines in the paper are simply conflicts of interest. And that at its core is what this agency cost theory is. It's really talking about conflicts of interest. But sometimes these problems in the trust context arise not from conflicts of interest, but just ineptness from the part of the settlor or just negligence on the part of the settlor. To resolve a lot of these conflicts and contradictions, so in Sitkoff's formulation, the proviso for agency cost theory is that you've got these pro-beneficiary interventions. They've got to be consistent with the ex-ante instructions of the settlor. So then Sitkoff is trying to give you some sort of a back-end check. This ensures that efforts then to maximize beneficiary welfare also have to account for settler welfare. But that balancing then becomes a little wonky in itself so as to become fully meaningless. And then you've got other follow-on questions like, well, to what degree should trust law defer to settler preferences? All these are questions that Sitkoff leaves open. So the other kind of dispute is this long-standing dispute in trust law over whether trusts are fundamentally more contract or more property. And then that segues into the next pillar of law and economics analysis. Now, when Henry Hansmann and Ugo Mattei had pioneered this kind of what they said is law and economics analysis, they really rested this on the property pillar. They said that a lot of this earlier discussion was rooted in contract, and it really overlooked the core property features of trust. So for Hansmann and Mattei, they said, let's get back to organizing principles or the fundamental principles of trust. Trusts are fundamentally all about property. And in saying that this is all about property, Hansmann and Mattei are saying that what they really mean is the ability of trust to segregate assets or to partition claims or to partition assets. So the roots here, because I think it's important to think about what the precursors to this debate are. It's this debate between two really well-known, long-standing debate between two really well-known trust scholars of generations ago. There was Maitland and Scott. There's long-standing debate, are trusts more fundamentally contract, or are they more fundamentally property? So Hansmann and Mattei, they said that, look, trusts are really all about property. And they think of this reorganization of rights and responsibilities vis-a-vis third parties, that is mainly creditors. They couch that in terms of property. I think a lot of you who study like the organizational form and coming at it from the perspective of business law or even agency and partnership law, you would quibble with that. It doesn't sound like it's property. It sounds like it's more the law of enterprise organizations. There's somebody else, so M.W. Lau, who's much more contemporary. He takes the approach that, well, Hansmann and Mattei are taking this really entity approach to trust, but trust does have core property features. And really the real property-like contribution to trust law is the ability to manage and to steward assets over many, many generations. There are naturally criticisms, but before I go to the criticisms, here I think it's also useful to think about analogs between corporate law and contract law. So if you think of an entity like a corporation, the corporation's got shareholders. And then it's got a board that's managed by it, and the board might have directors. What Hansmann was saying, Mattei are really talking about are you've got creditors of both the corporation, and then you've got creditors of the shareholder. But they can only go after the assets of their particular debt. Shareholder creditors can only go after the assets of shareholder. Similarly, corporate creditors can only go after the assets of corporation. There's going to be this artificial distinction between the corporate creditors, shareholder creditors, with the corporations. Yes. Oh, you can enter into contracts, sue, you can hold assets. Oh. And here is this partitioning that says that trust law replicates. So then if you have trust, and then you have beneficiaries, and then you have the trustee, and then you have a creditor. But if you have a creditor of a beneficiary, if you have a spendthrift provision, that's going to mean that the creditor can only go after the assets of the beneficiary, but cannot go after assets that are locked up in trust. But there are exceptions to that. From corporate law, you know that there's piercing the corporate veil, which allows corporate creditors, to pierce the corporate veil and then to get at the shareholder. Of course, reverse of corporate veil here, so we've got a shareholder creditor, they can go after assets that are deposited in the corporation. And similarly, if you've got a trust that's got a spendthrift provision, and maybe something that's more similar to the corporation is if you've got a self-settled trust with a set spendthrift provision. In other words, if you've got an asset protection trust, there are exceptions in which creditors can go after the assets of the trust itself, and to kind of unwind this artificial distinction between the entity of the trust and the beneficial owners of the beneficiaries. So what Hansmann and Mattei are saying is that, you know, this kind of partitioning, asset partitioning, is really rooted in property. I think the criticisms are one that's on a technical level, which is it's not really rooted in property. It's going to be more rooted in the law of enterprise organization. And I think that there are some criticisms. So I think that the criticisms are where we can begin to think about what the macroeconomic implications are. And the criticisms are, if you adhere too strongly to this artificial separation, that you sometimes will externalize these negative externalities. So if you've got shareholders that have behaved very, very badly, or if the corporation behaves very, very badly and takes on a number of liabilities, be they in contract or in tort, that if you make it impossible for the corporate creditors to recover fully because the corporation is going to be minimally capitalized, and you don't permit corporate creditors to go after the assets of the shareholders, that's going to be this negative externalities. It's going to induce bad behavior simply by reorganizing your obligations into the corporate form. It's a similar set of discussions for spendthrift provisions, which is you incentivize really, really bad behavior. And at least in the US, there's some really colorful spendthrift provision cases where beneficiary creditors and contractor and tort are simply not able to recover against the trust assets. And this can be for really egregious torts. So some of the really classic cases, there's one really well-known one, Shovel versus Kruger, which deals with a beneficiary who was a tortfeasor, had sexually assaulted a minor and then broadcast it online. There was a judgment, could not recover. The principal assets of the tortfeasor debtor were held in trust. Trust had a spendthrift provision. So then you begin to think about the criticism of enterprise organizations is if they're too airtight and you don't allow for recovery for equitable principles, then you're going to have all of these negative externalities. Okay, so I think in my last 15 minutes, I'm going to end with what I think is the most really interesting development over the really last few years. It's been about the last decade. I think a lot of the scholarship really came after 2016. I think after 2016, with a populist rightward turn in a lot of Western democracies, everybody was all of a sudden really interested in inequality, and everybody all really wanted to have an inequality nexus to the legal research that they were engaging in. So I think from the macroeconomic perspective, it's important to note that trusts are going to be an input into the broader economy. And the way, so some of the more macroeconomic scholarship, I think of them as macroeconomic because this is kind of a survey. That's how I classify them. The scholars themselves who are working in this area would not say that they're taking a macroeconomic view, but I think that they really are because they're really talking about the contribution of trust to perpetuating wealth inequality. So that's why I think of this as macroeconomic. So a lot of the scholars would say that trusts really lock up wealth for the extremely wealthy ends of the spectrum. And one very clear way that that comes through is going to be the estate tax. oh, sorry. So this is the estate. Oh, so this is the estate tax. So the way the estate tax works in the US is that you've got the federal tax, and there were all sorts of exemptions. So one clever way early on that settlers would evade estate taxes, estate and gift taxes, is that when they knew that if they were going to pass and their estate would be taxed, they would simply devise all of their assets and skip a generation to the next generation, and that was not captured by the estate tax. Well, in 1984, Congress passed what's called the generation skipping tax transfer, this GST tax transfer exception, and that kind of closed that loophole of generation skipping transfers to get around estate taxes. There's a really major loophole in that though, in that if you've got assets that are settled in trust, they're not taxed until the trust terminates. And that means then that the federal estate taxes are going to have a nexus with state law, specific law of the rule against perpetuities. Now, in many jurisdictions, the law against perpetuities, the rule against perpetuities has been abolished. Not so in a lot of US states. So this is all going to be state law. So rule against perpetuities, we teach that in property. It's like the bane of students' existence. It's like really complicated. Students hate it. For practitioners, they think of this as a malpractice trap because it's really, really hard to plan for the rule against perpetuities. So over time, different states began to experiment with peeling back, with kind of undercutting the rule against perpetuities. First, there was this wait and see period, like let's just wait and see to see if the rule against perpetuities is going to be violated within, like, say, set number of generations after the settler has died. Then there was a statutory period, which was trusts are valid for 90 years. Then some other states said 100 years. Not to be outdone, still other states said 1,000 years. And then finally, some states started just outright repealing the rule against perpetuities. So what you would see then is you would see wealthy settlers putting away their assets in trusts that would never terminate, or they were domiciled in states in which they had a really feeble rule against perpetuities. And this is coming at a time in which at the federal level, you see the taxes, the way they begin to be undercut is that, first of all, there's an exclusion or exemption. So states that are below this level will not be taxed. And this exemption has grown over time. With the 2000 tax cuts of George W. Bush, we thought that this was a lot because the exclusion grew to $1 million. Now the exclusion with the Trump tax cuts is going to be north of $11.5 million. That means if you die within the state that is less than about $11.5 million, you will not be assessed estate taxes. And the top rate, which is the top marginal rate, has fallen over time. So that means that because the surest way to get around wealth inequality is going to be redistribution through the tax and transfer system, through the tax system. So the taxes are the most efficient, transparent, and accountable way, far better than private law, to effectuate redistribution. That means that your most powerful tool to effectuate redistribution has really been undergutted with a combination of the repeal against the rule against perpetuities, and then the decline in the top marginal rate, then the increases in the exclusion. And then I think that there's another dimension of kind of the macroeconomic view of how trusts interface with the larger economy. And that is, if trusts are really a tool of planning for the super wealthy, for ultra high net worth individuals, trusts do have a hand in fomenting inequality. And why is that not good? So some of the folks who've written on this have said that looking beyond in the traditional macroeconomic perspectives, they brought in the work of some really interesting macroeconomists to look at the deleterious effects, societal effects of what happens if you've got a society with extreme inequality. And the economist that's most closely associated with this is Miles Korak. He's a Canadian economist. He came up with this graphic, which is called the Great Gatsby curve. And he's shown this close correlation between both high wealth inequality in societies in which there's very, very limited intergenerational economic mobility. So how does Korak measure that? So it's really interesting because Korak has availability. He has tapped into a lot of tax returns. So this is the kind of like big data research that's been pioneered with folks like Thomas Piketty. So Korak has looked at a lot of tax returns, and he's looked at the Western industrialized nations. And he's established this really tight correlation between parent-child earnings. It's really father-son earnings. It's for some really gendered effects. But it's really very, very close correlations between father and son. And that's what he calls the elasticity of intergenerational economic mobility. And just to distill it to this is to say that this is going to be highly elastic, which means there's going to be very close correlation in societies that have higher degrees of wealth and equality. You're going to have lower degrees of intergenerational economic mobility as measured by closer correlations of father to son earnings. So that's to say that if we want to have a society in which you're not going to be locked into the station that you were born into, in which you're not going to, be trapped at the station of your parents, then we should try to find ways, to undercut trust. And that's what a lot of this, where this area of research is. And then finally, I think I'll just end with just kind of a catalog of some of the other research in this area. So this is going to be broader than trust law. This is going to be succession law more generally. So this is going to be associated with kind of a narrow burgeoning group of progressive trust scholars, where really they call themselves like critical trust and estate scholars. I guess I count myself as kind of one of that group kind of tangentially. So these would be people in America like Allison Tate, Bridget Crawford. So they've run a series of conferences thinking about the role of trust law, but more broadly succession law in perpetuating wealth inequality. And some of the work of these scholars at the very low end, they've looked at intestacy and how intestacy is terrible at keeping wealth within a household and trying to reform intestacy. So there's a slew of academic proposals around intestacy to try to make intestacy less prevalent. Reed Weisbord has said that, if you file taxes, you should have to also be forced to do a will. There are others who've said that intestate preferences should track your predetermined contractual preferences. If you've got like some sort of a non-probate asset, like some sort of retirement agreement that espouses who you view as your beneficiaries, that intestacy should track that. So at the higher end, there are folks who are sounding kind of the alarm about trust. Eric Cades has said that trust lock up a lot of wealth. And that's not really good because you have a lot of assets and a lot of wealth that could be circulating the broader economy, but aren't. I think one of the challenges, I think that's very perceptive. And so what Cades has said is that, look, there's this golden rule of savings, that sometimes if you have societies with a lot of savings, that's going to cause the society to economically stagnate. So Japan, for instance, is an example of a society that has a really high savings rate. There's a rate that's called the golden rate, and Katie says that when savings exceeds the golden rate, you should be much more aggressive at unwinding trust. So I think that's good, but to push back even against Katie's argument, it's been shown that what happens when extremely wealthy settlers don't save and when they begin to invest, there's a lot of asset bubbles that happens. And there's a literature from financial regulation that lays blame of the financial crisis at the feet of very, very high net worth individuals, what funnel their assets into these quirky, exotic financial instruments and into real estate, creating these real estate and asset bubbles, and that's not good either. And so I think what happens is, and this is kind of at the infancy of law and macroeconomics or trust and macroeconomic analysis, is that there has to be more research into whether if you tinker with trust on one hand, are you trading one type of inequality for another? I think that's where I'll end.
Thank you so much, Felix. In just 40 minutes exactly, you have given us a very comprehensive, very insightful and critical survey of the literature on the economic analysis of trust. If you find this very helpful, wait till you actually read his book chapter on this, which will be appearing in the Oxford Handbook of Comparative Trust Law. I believe the online version of the chapter will be available soon, so just go and check the OUP website. And the actual book, the printed version, will be published in 2026. So watch out for that. And for participants of this seminar, we will be distributing you his paper, his draft book chapter through email after this seminar. So thank you again, Felix.